Eduardo has his hand up. Eduardo, do you want to contribute something?
Yeah, I just want to tell everyone that in my experience in trying cases and in talking to jurors afterwards, they really do pay attention. And I've sat on juries. I've been called several jury panels. So I've sat out there with the people without them knowing I was a lawyer, and you know, people tend to complain and bitch and moan about, you know, losing a day and going to the jury panels and so forth. But once they get on a panel, once they get in front of a judge, they really start paying attention to what's going on. And they do pay attention to what the judge tells them about the whole process and the instructions that he gives. And so, that being said, it's important to me that we continue to have language that the court gives to jurors about bias and prejudice and I guess echoing a lot of what Richard has said. But I think it's important that we know that jurors, once they get in a panel in front of a judge, not the big jury panel, but individual panels that are being selected for jurors in a particular trial, they really start paying attention to everything that the judge says. And in talking to them after many trials that I've lost, they have taught me that they pay attention and do the very best that they can to follow all of the jury's instructions, all of the instructions, including calling each other out when they're bringing up issues that might be where they might not be following the court's instructions on bias and prejudice. I just want to let you all know that.
Thank you. I'm just going to disagree with one thing, Eduardo. You have not lost many jury cases. So I'll dissent from that statement. Judge Miskell.
I think just to summarize what I've heard a lot of folks saying so far is we don't think this instruction will actually change anything, but this is an important subject and the judicial system needs to send a message about this. And so I'm just questioning whether the jury instructions are the best place for that. Because I think the rest of the instructions tell the jurors what to do, like, you know, don't flip a coin, don't trade your votes, don't make up your mind first and then figure out the numbers. But I guess I'm just wondering, what is a juror going to do after reading this instruction? You know, we're telling the juror, don't make a decision based on biases you don't know you have. The whole preceding voir dire process, the purpose of voir dire is to get into investigating bias and talking about bias. So I'm not sure what this particular change adds.
Okay, thanks, Judge. And it's a very salient point. Professor Carlson?
Amen. Looking at it from the big picture, in response to what Judge Miskell just discussed, I think it's really important that we emphasize to the jury that you decide the case on the admitted evidence. Because I don't think a lot of jurors really think about that enough, as opposed to what they bring with them as they walk in the door. That's it.
All right. Thanks, Elaine. Kenan.
I love following Professor Carlson because I can say, I agree completely.
That's what we do with her.
Yes, yes. I'll add that we already have in these standard jury instructions language about bias and prejudice and sympathy, right? So this isn't a novel concept. It's already there. And part of what the goal was underlying the additional language is to get the jurors to think a little bit more about these things that shape our decision making without us even being aware of it. And I know that we're not going to solve a problem relating to implicit bias with some additional words and jury instructions. But it's amazing how powerful recognizing this thought process can be in relation to how we assess ourselves and the decisions we make. At least for me, in delving into implicit biases, I've discovered things about myself that I wouldn't have had I not gone there, had I not ever thought about it. And so I don't want to discount the power of putting some additional words in these instructions to help the jurors think a little bit more about what it means when we say already in the instruction, do not let bias, prejudice, or sympathy play any part in your decision. We get them to think a little bit more about what we mean by that and delve a little deeper. And I don't see harm in that. I don't think it's the solution to implicit bias and what that can do in regard to our decision making. That's not ideal for juries and decision making processes in the judicial system. But I go back to what other people have said, and that this is important, and I don't want perfect to be the enemy of good in doing something more than we've done already to help jurors and potential jurors think about how implicit biases could shape their decision-making processes.
Great, thanks, Kenan. Sorry, David, no, Lisa Hobbs, then David Jackson.
Well, and also to follow up on that and to sort of answer Judge Miskell's question that I think was more rhetorical than deserving an answer, but I can't find it right now as I was preparing what I wanted to say, but in the materials I read last night, there was a Dallas County pilot program that used implicit bias instruction as a pilot program. And the result, and then they surveyed the jurors afterwards, and it was a significant number of jurors who said, it did make me stop and think, much like what Kenan is saying, this process, as we've talked more and more about implicit bias over the last few years, has done for her. These jurors are saying, I noticed that instruction, and I think it made a difference in how I deliberated in the case. And it was a pretty high number, over 50%. And I'm sorry, I can't find where I read that now. Maybe because we got 31,000 pages of things to read in one night. Anyway, that's my comment.
Okay, thanks, Lisa. David Jackson.
I just have a quick procedural question. I've noticed that we've had a lot of chats popping up on the screen. I think we need to make it clear whether those chats are on the record or off the record, because I don't think our court reporter has the ability to listen to what's going on and read the chats.
Yeah, and that's my fault. And then currently they are not part of the record because I have not been reading them out as I did at the last meeting. And so I'll try to do better. But thank you for pointing that out.
I just didn't want anybody to think they were making a brilliant comment that never got noticed.
No, very, very, very apropos. And I didn't frankly notice the chats until the last break. So I'll try to do better. Scott Stoley.
Thank you, Chip. I think one way to say what we're trying to do here is to encourage jurors to engage in some self-examination. And although that may be a fool's errand, even if we can only get one juror in one trial at a time to engage in more self-examination, I think we've done something good. So I'm in favor of doing something like this.
Great. Thank you, Scott. Let's turn now to our next agenda item, which is jury rules. And the same subcommittee is responsible for this as the last one. And Professor Carlson and Tom Riney, which of the two of you is going to present on this, or is it going to be a third party?
Tom is taking the lead.
Thank you, Chip.
You bet.
We were asked by Justice Heck to take a look at the jury rules because he said they were outdated and do not reflect common practice. And if you study those rules, you will see that that's a bit of an understatement, as we will see in just a moment. Secondly, he asked us to consult with the Remote Proceedings Task Force to see if there's anything in the rules that would prevent a barrier to remote proceedings. Our conclusion is that the only rule that really would have to be substantially rewritten is Rule 226A, simply because it just assumes that the people are all there present. So depending on what comes up with respect to remote proceedings, we think that Rule 226A would have to be substantially revised. Now, one of the things that we want to point out is that in addition to these rules of civil procedure, there are statutes on juries in Chapter 62 of the Texas Government Code. They're also outdated in many respects. If you look at those statutes, like the rules, they assume that the jury is actually being selected by pulling names off a jury wheel. That they assume that's physically being done. That's even contemplated if there were a jury shuffle. We talked about that on our committee, and we could not find, at least no one on our committee was aware of a county that does not use computers to randomize the selection of jurors. It's allowed by statute, although again, some of the statutes are outdated as well. So one of the things I did was talk to one of our Texas Panhandle judges who has 5 different counties in his district, including Roberts County, with a population of 929 people. And even Roberts County uses a computer for jury selection. So unless someone else has some other information, we are going to assume that everybody now uses a computer and nobody's using the jury rules. Before we go into any specific changes, our committee also recommended that we might want to take a look at trying to put some of these rules in plain English. I suppose that could also be said about a lot of our rules of civil procedure, but we did endeavor to try to simplify some of the language. Not only do the rules talk about practices that are no longer followed, they use language that it was in some cases archaic and just difficult to follow. So Chip, if it's okay, I will go through the rules that we have changed and then just pause at the end of each of them. Would that be acceptable?
That would be terrific, Tom. Thank you.
All right. Now you'll notice that in some cases we have combined rules, and the first place to start would be Rule 221 in your materials. And we combined Rule 221 and 222 by making a subpart A and a subpart B. That'll give you an idea of the method that we were using with respect to some of these. And we basically just eliminated the language about drawing names from a jury wheel. We decided the rule initially said that you could challenge the array if the officer summoning the jury had not followed the legal or statutory requirements, acted corruptly, or had willfully summoned jurors. We took out acted corruptly simply because we would presume that if you acted corruptly, you've not followed the legal and statutory requirements. And then, as I mentioned, we put Rule 222 as Part B because that seemed to be part of the same topic. That is the challenge of the array and what happened with the outcome.
Hey, Tom, could I interrupt you for just 2 seconds?
Sure.
Do you know the origin of the acted corruptly language?
We do not.
Does anybody on the committee know the origin of that? Yeah, Justice Christopher.
Oh, sorry, I don't know the origin of that, but I argue that we should not take it out. And I think we need to wait and see what happens in the Brazoria County investigation.
I-
I don't know if y'all are familiar with that.
I will add that I became aware of that after the time we changed this language, and I'm not familiar with the details, but I from the little that I know, Justice Christopher, I agree with you. Before we change that, perhaps we ought to pause a little bit.
Okay.
Yeah.
I don't know what is going on down there either, but big investigation.
Yeah.
Yeah. And I don't know for sure, which is why I asked the question, but I thought that was put in there to cover a situation where somebody, might have been following the statutory requirements and yet had a perhaps bias that was informing what they were doing, a bias that would be unconstitutional. I don't know that for sure, but anyway, I agree that I don't think it should be taken out. I think it should be left in there. So didn't mean to interrupt, Tom, but go ahead.
No, not at all, Chip. That's a good point. And although I can't specifically say that the subcommittee voted on this, I think we would all recommend that the legislature take a look at these statutes as well, because they just definitely need some work.
Yep.
All right, let me mention next that because we have combined some rules, I don't think we've done a good job of going back and renumbering them. So these rules would need to be renumbered. Let's go now to what would be the current rule 225 on the next page. The title of that rule is Summoning Talesmen. And I want to thank Justice Heck. This gave me the opportunity to add to my vocabulary. I've looked at that rule and never even realized how to pronounce that word and had no idea what it meant. But talesman, according to Black's Dictionary, in case some of you were as unfamiliar as I was, is a person who happens to be standing around the courtroom when you don't have 24 jurors and they just grab them and say, okay, you're on the panel. That's a talesman. And we don't think anybody does that, and that it might not be a good idea. So we have recommended elimination of that rule.
I will tell you that in certain JP courts, when they don't have enough jurors, they'll go out on the street and just bring some people in. But I agree with you that probably should be eliminated.
Okay. If there's nothing else, I'll move on to 226A.
Yeah.
All right, 226A. We treated these separately, the implicit bias instruction and then what we needed to do to update things. And I apologize. I did not notice until yesterday that some of the red line just did not make it onto this final copy. So the language that you have for 226A does not have the red line. Let me explain what we did differently. If you look at the instructions to the jury panel and jury, you'll see there on the bottom of page 3, it says, before we begin, please turn off, well, it doesn't say please, we added please turn off all cell phones and electronic devices. Now we updated the language. It used to say, don't go to social networking websites such as Facebook, Twitter, or MySpace. We think it's better to refer to Facebook, Twitter, or other social media platforms. That same change is incorporated in instruction number 3 on the next page. And I'm not going to go through each of them, but every time that language applied, we made the same changes. Then if you'll go over to page 5, you'll see paragraph number 6, do not investigate this case on your own. We have given some more specific information about what the jury should not do, taking into consideration the proclivity to look things up on the internet. I mean, we've heard examples of people, they're sitting there in the jury box and they hear something and they try to look it up on their phone immediately. And so we have tried in in instruction 6 to give some specific examples of what the jury should avoid. Then we added the next paragraph about this rule is very important. And kind of like the discussion we had a little bit ago about the implicit bias instructions. We think that the jurors do listen to what the judge says, and sometimes something specific is helpful. So we've tried to explain why they shouldn't do that other investigation that their normal habits would cause them to do. And then we add another paragraph that says you must follow these instructions. And if you don't, it not only might have to require a new trial, the judge may also hold the juror in contempt for violating the instructions. Now, let me pause there because I think those are some of the significant additions that we added. See if there's any discussion.
Anybody have any comments about what we have so far as Tom has outlined? Yep, Justice Christopher.
Well, I do remember that the pattern jury charge put in that we might hold you in contempt of court, and the Supreme Court already took it out. So that particular thing had been brought up in the Supreme Court Advisory Committee. I think you all approved it. And then in the final ones that came out, the Supreme Court took it out. Just before we go into a long discussion about that again.
But we have new members of the court now.
Well, true.
And some of those members were on the Supreme Court Advisory Committee that recommended that.
True.
Good point, though.
No, I was against the contempt.
What else, Justice
Christopher? I think someone on our committee did bring that up. I'm sorry.
Okay, all right. I mean, I would like to bring up the shuffle again, but I know I've lost that vote many times.
But always in good spirits.
Okay.
Lisa Hobbs.
Well, I'll stand with Judge Christopher. If we want to revisit the shuffle, I'd like to revisit it too. Tom, did you guys pull up the 1996 task force? It was like a jury selection task force. They did a report, and I think it was around 96.
Well, the answer is no, we did not, or I did not.
I might pull them back. Actually, it was later than that. I wasn't practicing in 96. So I was rules attorney, I think. So it would have been like 2004, maybe. Justice Heck might remember. But some of these rules, I think it was more statutory, like, do we need statutory changes and stuff? But I do think we went through the rules too. So just, I commend that to you as you continue to study these. On 225A, just going back a little bit, because there doesn't seem to be a lot of conversation about that. But as I read 225, it's a randomization rule. So to the extent you do go out and grab somebody off the street, make sure you don't just add them to the end of the row here. We want you to get them randomized, right? So unless there's a statute prohibiting people from going out and getting people off the street, I kind of like that rule being in there that they should be, shuffled, not to use the word shuffle, because I don't want to, that's a loaded term, but they need to be randomized into the pool that came in as they were summoned. So that's just a general comment about that, because it sounds like at least Chip thinks it might be happening, at least in JP courts. And then this is just, you said something about renumbering, and please don't renumber. I would rather have gaps in numbers than not be able to search 226A. It's from research purposes, like, please don't renumber, just take out a rule. That's fine. It doesn't, those were just my general comments so far. And just I'm sorry, one more For clarification, everything on page 5 of the PDF under paragraph 6, before do you understand these instructions, that whole like kind of 3 paragraphs, that's all new, even though it's not redlined as such.
Well, to be accurate, I'm going to have to look at my,
Okay, it's okay. I can pull up my rule book too. I was just
Okay.
curious if that was all newly drafted or if it's kind of just edited.
no, subpart B is added. And I think, well, actually, subparagraph E used to talk about don't look stuff up on the internet. And what we did was we expanded that, and then we moved it up from the bottom to the top, more or less, because we thought that it merited more attention near the top.
And then the next 2 paragraphs, are those just edited or are they brand new?
Let's see. The rule is they are edited,
Okay, thank you.
and except for the paragraph about each juror must obey my instructions, we added that, I believe. I know we added the part about contempt of court. Okay, just looking at my rules, it appears to me that's a whole new paragraph. Each juror must obey my instructions.
Okay,
And
thank you.
that's my recollection. And the only other significant change in Rule 226A is over, I believe that it's on page 7, the sentence before paragraph 7, we're repeating this instruction about don't investigate the case on your own. And we added the sentence says, if you observe any juror violating this rule, please report it to the bailiff for me immediately.
Great. Does that cover it, Lisa?
Yes, thank you.
You bet. Rich Phillips.
All right, I'm going to turn my camera off, so hopefully we won't have the same problem as before. I like the change to the internet stuff, but I'm a little concerned because, well, first of all, Bing is going to be like MySpace, or may already be like MySpace. And Safari is not a search engine. It's a web browser. So I think we need to be a little careful about what I think it's great to tell them don't use any search engines, or any electronic devices, but we need to be sure that we're putting the right sort of terminology in there and not suggesting something is a search engine that is not.
Great. Thanks, Rich.
I think we would agree with you on that. We spent some time on this. We were trying to not get back into another MySpace situation, and we welcome any comments on that.
Richard Orsinger. Unmute yourself, Richard.
Just to follow up what was just said, I did a search for search engines, and Google in 2020 had 92.5% of the market, Bing 2.44, and Yahoo 1.64. So it's so dominant, I would suggest we say like Google and then stop there.
To further their dominance.
Well, I think that if we don't put like Google, they may wonder what we mean. But if we put like Safari or like Bing or anything else, we'll just confuse them. So
okay, yep. All right, Tom, you want to keep going, or?
Yeah, if that's okay.
Absolutely, let's do it.
Let's move on to 227. Now, I realize now that there's going to be some criticism of this because we've changed the rule number and moved it. But let me explain why we did it first. Rule 227 used to be Rule 230, and we we have revised the language a little bit. Let me read you current Rule 230, since I did not get that in red line. It says when 24 or more jurors, if in the district court, or 12 or more if in the county court, are drawn, I'm sorry, wrong one. In examining a juror, he shall not be asked a question, the answer to which may show he has been convicted of an offense which disqualifies him, or that he stands charged by some legal accusation with theft or any felony. Now that follows the rules regarding challenges for cause. And so we thought it might make more sense to put that question prior to the time that we're talking about challenges for cause, because that would seem to be where it would go logically. But again, I don't think that's crucial. You can see we also tried to rephrase that rule so that the language is just a little bit simpler. I don't know if we accomplished it or not, but that was our intent.
I don't know if this is the majority sentiment, but I would join those who said, don't renumber the rule, just leave blanks if we have to.
I'm sympathetic to that argument, and we had not thought about that. Okay, so what is current, what I have now, let's go to Rule 228. Challenge, we call it challenge to juror. And what we have done there is basically, this used to be Rule 227, so we probably should keep it the same. And let me double check, but I don't think there were any real changes. There were no changes on that.
Okay.
And then on 229, we tried to combine, we broke down 229 into a challenge for cause. And I think we broke that out. I think on that one, we just thought that it read better if we broke it into subparts A and B. Hang on, Chip, just a second. Let me make sure that's what we did. I'm sorry, my notes.
Okay, that's fine.
Okay. Actually, what part B does is, it just breaks it into two parts and tries to clarify some of the language.
Okay, Judge Christopher has a question at this point.
Okay.
Judge, you'll have to unmute.
Sorry. So I'm a little concerned about Rule 230 and why it was ever in there to begin with, because when jurors go through the qualification process, often a judge is there doing it. And one of the disqualification matters is that you've not been convicted of misdemeanor, theft, or a felony. So, I mean, jurors are asked questions to show if they've been convicted, and a person is disqualified if they have these convictions. So I'm not sure where that rule came from or why it should be in there rather than just being rewritten. And it kind of depends on, in some places, the clerk asks all these questions, but the jurors are always sworn in and, giving them an oath in terms of their qualifications, and you have to say you're qualified. So I don't know. I wonder why it was ever in there to begin with when, we do ask people to self-disqualify themselves in open court.
Now, we did add in our rewrite of that rule that about just not asking it within the hearing of the other jurors or in the presence of the other jurors.
But I mean, that happens. that happens when the jurors are qualified before they ever come to the courtroom. Right? So, and in some cases, the jurors are qualified in the courtroom with all the parties there before voir dire starts. Like in smaller counties, that's what'll happen, right? But, you know, in the bigger counties, the qualification happens, you know, in the jury room and you lawyers never see it. But I mean, they're asked in open court and they're given an oath to, you know, identify the, you know, I mean, is it in the courtroom? Well, kind of, and sometimes it is in the courtroom. So I don't know, it's just an odd rule to me that I've never focused on. And before we just rewrite it, I think we ought to think about it.
Thank you.
Well, you've got a point, particularly in the smaller counties where they report to the courtroom.
Right.
Okay. All right. On rule 231, we thought that rule really wasn't necessary because if you take a look at rule 232, let me explain that. Rule 232, we've changed the language because the current rules, you know, tend to just talk about district courts and county courts, and that's no longer appropriate because some county courts at law in certain cases have 12 jurors. And therefore we've tried to change the language to talk about you know, situations where it's just either a 12-person jury or a 6-person jury. Whether it is a 12 or 6 is determined by the statutes, not the rules. So we've tried to combine that with Rule 233 on peremptory challenges. And other than that, we really didn't make any additional changes to the existing rule 232, 233. There was some discussion about the motion to equalize and whether we should change the language on equalizing the number of peremptory challenges. But after quite a bit of discussion on a couple of different occasions, we decided to keep that language the same. Our experience was that there was a lot of case law about equalizing strikes back in the 80s, but that there has not been a lot of controversy since then. And so, you know, one might conclude that there is an understanding among the bench and the bar as to what that term means. And so probably we ought not to endeavor to try to change that language. Let me also mention we added a comment to what was Rule 233. This has always been very puzzling to me. The rules of civil procedure determine the number of peremptory challenge for the actual jurors, but then one has to go to the Texas Government Code if the court decides to seat alternate jurors to determine how many strikes that you get for alternate jurors. And it depends on the number of alternate jurors that the court allows. One strike per side for 1 or 2 additional jurors or alternates rather, and more if there's more alternates than that. So we thought that it would be helpful both to the court and to practitioners to add this comment about looking at the Texas Government Code. Any questions there?
Okay, any comments on the matters that Tom's been talking about up to this point? No hands up. There's one, Justice Christopher.
Sorry. So I've had a situation where, as we're going through voir dire, I keep track of challenges for cause, right? As we go through, and I know that about 2/3 of the way through the voir dire, I don't have enough jurors, right? So I usually stop then and bring over more jurors, as opposed to waiting until the very end. So I don't know if I was doing it wrong or what, that it has to be done this way. that it has to be, we have to wait till the very end and let people make peremptories when I know there's not going to be enough jurors. It's just a question. I don't know the answer to it. No one complained, so there was no appellate ruling on my decisions.
Yeah, and in small counties, sometimes you don't know, you're about to bust a jury, but there's nobody waiting in the waiting room, like in Harris County, to even call in more ones. So I've definitely have judges warn me, y'all keep it up and you're going to bust this entire panel.
Mm-hmm. Okay, Levi.
There was a headline I saw, I think last week, from the National Center of State Courts. I didn't read the article, just a headline, and maybe others saw it, where Arizona has barred peremptory strikes. And I don't know how this discussion is going to end today, but if it's going to end, if it's contemplated that it might end with a vote and a recommendation to the court, I'd like to see us put that off until we have the opportunity to consider what Arizona may have done based on the headline I saw.
We'll follow your recommendation if you tell us if you're in Arizona.
No, sir, I'm surprised you would have to even ask. I'm in Wakanda forever.
Okay. Yeah, I don't know where this is leading us, Levi, but we got your thought in the record, so we'll keep going.
Okay, thanks.
Okay, let me move on to the next one, which is some language change in Rule 234. We were advised that in certain courts, it's not actually the clerk that handles the challenges, handles the peremptory challenges rather, that the list may be delivered to the court's designee. That may be the clerk, it may not be. So that was the reason for that change. And we also made the change regarding if the case required a 12-person jury and so forth, instead of just saying district court.
Professor Carlson.
Yeah, Tom, did you want to mention anything about Rule 233?
Yes, I think I skipped right over that. Hang on just a second. Okay, 233. Elaine, I'm sorry, which one? My numbering is off, so I don't have that right.
C.
Okay, I'm sorry, I'm not following what you're asking me. The one on peremptory challenges?
Oh,
okay.
Sorry, Tom. No, the shuffle. Where did that
okay. Yeah, that is the one that I overlooked, and I apologize for that. And that was one where we decided not to get into the issue on the shuffle, but we noticed that the way that the rules had been drafted, that's 224, I think. Yeah, 223 and 224. 223, as it's currently written, talks about jury list in certain counties, and those are counties that are governed by interchangeable jury statutes. And they talk about preparing the jury list, and then it talks about the shuffle. which is mentioned is in subpart C of Rule 223. But then Rule 224 talks about preparing the list in those other counties that don't have interchangeable juries. And what we tried to do, and again, I recognize the problem of changing rule numbers now. We tried to put it all in one rule, and then part C was the shuffle. The shuffle, of course, contemplated a mechanical shuffle, so we have now talked about random order. But also on Rule 224 in the counties without interchangeable juries, there's really no reference to a shuffle. Although I know everyone's always had the practice that the shuffle would occur in any county, regardless of whether there were interchangeable juries or not. So by combining them, that was our attempt to deal with that. But I do recognize the problem with changing the numbers.
Thanks.
Great.
Thank you.
Judge Miskell.
I was just going to ask, I know one of the tasks you were doing was revising for archaic language, and I think the oaths are very archaic. I know it says you just have to give those oaths in substance, and so I have rewritten them to be in plain language, but I don't think there's any reason in 2021 we need to be saying that you will true answers give, I think we can put that in a little more understandable plain language. I think 226 is a jury oath, and then there's also a jury oath. 236, and I would just request those be modernized.
Thank you. Thank you, Judge. For the record, Levi Benton gives us a link to a news article in bloomberglaw.com. U.S. Law Week, Arizona bans use of peremptory strikes in state jury trials. And there's apparently an article at that link that would be informative, according to Levi.
If I could just add there, Chip, that is what happened. And the Arizona Supreme Court did it because they didn't think that peremptory strikes could be squared with Batson procedure.
Okay.
Something that some of us have been saying for at least a decade. But anyways, thank you, Chip.
You bet. And we don't have to revisit the shuffle that you and I agree on, Levi, with perhaps others, but
yeah,
we've lost that fight, at least to date.
well, no, oh yeah, to date, right. But anyway, just to reiterate, I do support some of the suggestions of the committee. All I ask is that before any recommendation goes to the court, maybe we might study in more depth what Arizona has done. I don't think anyone on the committee would argue that Arizona is a bastion of liberals. So anyway, that's my comment.
Thank you. Anybody else? Tom, back to you, I guess.
That's pretty much it, Chip.
Okay. I will consult with the court, and if there are no further comments, we'll see whether the court is interested in more discussion on any of these issues, Arizona or any other state or foreign country that might have an interesting approach to things. So that'll take us, I think, to the next and last agenda item, which I think gets back to Bill Boyce, if I'm not mistaken. Our oft discussed suits affecting the parent-child relationship and out-of-time appeals and parental rights termination cases. Bill, I think you're leading the charge on this, if I'm not mistaken.
Correct. Thanks, Chip.
You bet.
So following off on the memo that you have dated September 1, I'm not sure what tab that is listed as. This is the memo addressing appeals and parental termination cases. Part of this memo, just because it's a multifaceted discussion, recounts the steps that we've taken already towards getting to resolution of some of these recommendations. If you want the roadmap, I will direct you to page 2 of the memo, issues for discussion. We are now looking at issue 1B, proposals for untimely appeals and ineffective assistance of counsel claims. Just for brief recap, going through the memo, and Lisa helpfully identifies this as Appendix P. Thank you. So we started out with notice of the right to counsel in the summons, authority to appeal. We spent a fair amount of time working through a proposed revision to Rule 306 that would specify circumstances under which an attorney is going to remain in the case or not. And again, just to put this in context, we're talking about that subset of parental termination cases where there is a right to counsel. I'm not going to replow all that old ground because we talked about it across multiple meetings and got to a recommendation that appears on page 4 of your memo. That was the discussion that was aimed at getting this determination about whether or not the appeal is going to go forward in the realm of a procedure under Rule 306, where there's kind of a binary choice about whether it's going to go forward or not. So we're going past that stage now and addressing the next portions of the inquiry. So if you go to bottom of page 6 of the memo, there's a relatively brief discussion. This is where the new part for today starts. The first part of the new part is subsection C, addressing motions for extension of time in these appeals. If you think back a little bit, you may recall that we had a prior discussion about this topic in relation to motions for extension of time to file petitions for review. And the recommendation that came out of that discussion, which was forwarded to the court, was in shorthand version, basically a no-fault motion for extension of time procedure, coupled with notice of the ability to pursue the petition for review. So in other words, not requiring showing of fault or good cause, but essentially an ability to file a motion for extension of time within 90 days after the appellate court rendered judgment or the Court of Appeals last ruling on timely filed motions for rehearing.
Bill,
yeah,
I think it might be better to call it a motion that covers a failure to timely file or extend before that, right? So it's a late, out of time petition for review procedure, right? Where the attorney fails to file it, is my recollection.
Right, and that is a more precise way to
okay, thank you,
articulate it. And the basic recommendation with respect to timeliness for the appellate process, for the intermediate appellate process, would be to conform that process to the process that's used in connection with an out-of-time petition for review. In other words, those procedures should sync up. And we can unpack that a little bit more. With the benefit of hindsight, it probably would be helpful if the prior recommendation had, if I had attached that to this memo, but I didn't do that. So we can unpack this a little bit more, but for our purposes today, the recommendation would be to sync up those procedures so that they operate the same in the Intermediate Appellate Court and in the Texas Supreme Court. And just by way of further background, the recommendation on the PFR process was forwarded to the court, and the communication came back that the court would take that up, that recommendation for the PFR process, collectively with all of these other moving parts that we've been discussing. And so that discussion on page C or subsection C of your memo is a kind of a shorthand rendition of this larger discussion.
Great. Before we have discussion about that, on the last topic, just for the record, there has been a chat involving Justice Christopher, Judge Miskell, and Richard Orsinger, where they are reminiscing about the old language of true verdict render, even if it's a little old-fashioned. And Richard Orsinger says there's something to say that using solemn language gives more solemnity to their duty to a true verdict render. And so the record will now reflect that yearning for yesteryear, which perhaps should be retained in this year. So sorry to interrupt. I'm trying to keep up with the chats.
That's a discussion that may be going on longer than even appeals and parental termination cases. So.
Yeah, right. Exactly.
Moving to subsection D, ineffective assistance of counsel. This has been the largest focus of the most recent discussion for the appellate subcommittee. And again, to put this in perspective, the House Bill 7, well, let me back up even a step beyond that. So we're dealing with those subset of parental termination cases in which there's a right to counsel. If there's a right to counsel, then it follows that there is a right to effective counsel. The standard in this circumstance with respect to parental termination cases following the Texas Supreme Court's decision in re MS follows the Strickland versus Washington standard from the U.S. Supreme Court for criminal cases and applies it in this particular context. To refresh your recollection, Strickland is a two-pronged test that requires a showing that counsel's performance was deficient, not merely bad, but deficient by showing errors so serious that counsel was not functioning as the counsel guaranteed under the Constitution. And secondly, that the deficient performance prejudiced the litigant by showing that they were so serious that they deprived the defendant, of a fair trial whose result is reliable. For purposes of our discussion, I think the main point to focus on is the timing and the circumstances of how a complaint like that gets raised and decided. In the criminal context, it is almost always done through a collateral attack, a writ asserting denial of a constitutional right to effective counsel. It is rarely accomplished in the direct appeal. It's not 100% precluded from happening in the direct appeal, but it is mostly precluded from happening in the direct appeal. Primarily, I think without going on a long detour, I think a shorthand version is that the four corners of a record alone are generally speaking not going to be sufficient to satisfy the standard under Strickland. There needs to be additional factual development, circumstances involving an ability of the counsel involved to address the circumstances. There are not very many situations where in the criminal context where it's going to happen on a direct appeal. And we've got an exemplar site in the memo, but across federal decisions or the Texas Court of Criminal Appeals, this discussion is generally channeled into a post-conviction collateral litigation attack on the conviction on these grounds. So that's the kind of the backdrop. The standard is parallel, but the question really to be discussed today is whether the procedure here is going to be parallel or not. And it takes us to the House Bill 7 Task Force recommendation, which is summarized in the memo that you have starting on page 7. The task force recommendation notes this distinction in the way that circumstances are handled in the criminal context versus the parental termination context, where as a practical matter, the parental termination litigation is probably or almost always goes through the direct appeal process, and that's the end of it. Where it ends up is where it ends up. And so the question arises: what then is the proper vehicle or mechanism to permit consideration of a claim by a parent whose rights have been terminated, that termination was the result of ineffective assistance of counsel? The House Bill 7 task force came up, met on this and deliberated and made a recommendation for an addition to Texas Rule of Appellate Procedure 28.4 sub D. That's shown at page 7 of the memo that you have, which, I'm not going to read the long rule to you verbatim, but the summarized version of it is essentially an abate and remand procedure on an expedited basis to consider during the direct appeal whether or not there is a basis for a claim of ineffective assistance of counsel. If you look at the proposed rule, subsection D, it contemplates that there'll be a short fuse on this, that there's a short fuse on filing it. There's a short fuse on deciding it. I'm not sure it says it 100% in these words, but as I understand it, and I think as the subcommittee understands it, it's a remand for an expedited evidentiary hearing in the trial court, during which the appeal is abated, and the time period of the abatement does not count towards the deadline under Rule of Judicial Administration 6.2a for the expedited determination of the appeal. So there's going to be a expedited hearing with a record that then goes up to the Court of Appeals after the abatement ends for consideration with the rest of the appeal. And so that kind of sets the table for the discussions that the subcommittee had. And again, I'm going to offer my summary of it and then certainly invite the rest of the subcommittee members to add their observations if there's anything that I omit or describe incompletely. But I think it's accurate to say that the subcommittee was in general agreement with this task force approach to create this mechanism for the consideration of the ineffective assistance of counsel claim in the direct appeal in some circumstances. But the issue that was identified and the issue that is going to be, that we're going to ask for the guidance of the full committee on is how to handle this in the circumstance where the same trial counsel continues as counsel for the appeal. The discussions we've had so far have indicated that many times there's going to be separate appellate counsel, different appellate counsel than trial counsel, maybe most times, but I don't know that there's a requirement or an ability to have separate appellate counsel for every appeal of a parental termination decision. And so if we're going to channel this discussion into the direct appeal with this abatement procedure, then it's one thing to say that new appellate counsel can come in, look at the circumstances, decide whether or not there's a basis to assert ineffective assistance, and then kick off that procedure. But if the same lawyer is continuing from the trial court into appeal, it seems to be untenable in the subcommittee's view for the same lawyer to be both pursuing the appeal and simultaneously asserting that that same lawyer was ineffective, even if there's a willingness to do that. It's a difficult position in which to put the lawyer if you're in the situation where the same lawyer is continuing on the appeal. And so the topic for discussion or the recommendation is for the committee, the full committee, to consider, do we want to have a situation where there is this direct appeal with an abatement mechanism in circumstances where a new attorney comes in for the appeal, but authorize a collateral attack? Probably it would fit within the realm of a procedure like an equitable bill of review, but that could be the topic of discussion. But as a conceptual matter, do we want to have an ability to have some level of collateral attack on a short fuse to address situations where ineffective assistance of counsel may be asserted against either an attorney who is the same attorney that handled it in the trial court and then pursues it on appeal, or separately, an ineffective assistance claim involving conduct of new appellate counsel that comes in that by definition can't really be addressed while the appeal is ongoing. So that's one of the topics that we will solicit the committee as a whole to give us their guidance on. A couple of additional mechanical questions or procedural questions that the subcommittee discussed. If you look at the proposed rule, the House Bill 7 Task Force recommended rule, the first words of the first sentence say, "For good cause shown by written motion filed no later than 20 days after the record is filed, the appellate court may order a remand for the limited purpose of holding an evidentiary hearing." So one of the points that we discussed was whether there is any appetite to try to further define good cause. And the consensus of the subcommittee discussion was that it would be very challenging and run the risk of being too limiting to try to define good cause in such a way that is sufficiently flexible to cover every possible permutation of ineffective assistance that somehow might get asserted. Bottom line, I think the subcommittee's sense was that better to leave that undefined, the good cause standard undefined in the rule, and allow it to be addressed and developed in the ordinary course of case law development as things progress. The related procedural or mechanical issue was whether there was any kind of additional qualification that should be put on whether or not an appellate court may order a remand to have this evidentiary hearing on ineffective assistance. In other words, is this just going to be a matter that's up to the judgment of the Court of Appeals? Should there be some additional standard applied? The one that was discussed in the subcommittee was some sort of a prima facie showing, with the thought that, again, the big picture here is that the balance that's going on is the balance between achieving appropriate and necessary standards to protect the terminated parent's rights versus not prolonging the process so much that the interests of the children involved are being compromised because their living circumstances and the identification or ability of a parent to participate in their lives is being kept in limbo for a prolonged period of time due to litigation. So that's kind of the balancing of interests that we've discussed in a couple of different contexts. So in this context, the balancing question is, should it really be left as this draft rule is, in terms of putting it in the court's judgment, whether or not a remand and abatement is appropriate, whether or not a sufficient showing has been made, or should there be some additional weight on that in terms of requiring a prima facie case or something along those lines. Again, an appellate court is not going to be constitutionally able to make any fact findings about anything, but it would be able to make a determination about whether it should be remanded to the trial court for whatever fact findings are needed to address an ineffective assistance claim. So those are the current pieces of the discussion that the subcommittee would ask for guidance on from the committee as a whole. But again, Chip, before we start off that discussion, I'd like to invite anybody else on the subcommittee to elaborate on anything that they think is needed.
Yep. Subcommittee, you're out. You're on. Pam.
Yeah, first, let me thank Bill for continuing to head this up. It really is very complicated because we're balancing so many interests and trying to do it in as efficient a way as possible. And it's very difficult to do all of that. In terms of moving the process along, I guess I would add that I do think if we do go with the ability to challenge in the direct appeal, that I would, at least in a comment, if not as a requirement of the motion, make clear that Strickland is the standard, and that the motion has to show the elements of Strickland so that the Court of Appeals has something reasoned in front of it, or that at least tries to parse out those elements and explain why there has been ineffective assistance of counsel. It's a very high standard. It's very hard to meet. Most of these motions will get denied, will not delay the appeal. But in those rare cases where it does happen, it would help if, the Court of Appeals had very clear statements in the motion that let it triage these and decide which were meritorious and deserved an abatement. It's a very short abatement to try and move the process along, but I would definitely want to see Strickland in the rule in some way.
Anybody else from the subcommittee? Bill, you've done too good a job. All right, Justice Christopher.
Well, the way it is currently written, we have good cause concerning an allegation of IAC. And to me, those things don't necessarily go together the way it's currently written. So I don't know how to rewrite it, but to me, they're not the same. I mean, so what are most of our IACs? Failed to object, failed to call a witness, did screwed up the jury charge somehow, right? Those are your main things, right? Those are all objective. Failed to object to something, failed to call a witness. Hopefully that's objective at that point after you've had some time to talk to your client. And, you've looked at the jury charge and it was a mess. Those are all objective things. Now, whether trial counsel had some strategy, that's unknown to the appellate lawyer, right? Which is why I'm concerned about these deadlines that you have in here. That's an unknown. What was the strategy? Failing to call witnesses. Well, I talked to the witnesses and they weren't going to be any good. That also is going to be unknown generally, right? So to me, I think it's an allegation of IAC, that's easy enough to make. But to actually prove in any sort of meaningful way what IAC is cannot be done, and we cannot review it on 3 days. I mean, especially if it's, you didn't object to this critical piece of evidence. Well, that requires reading the whole record to determine whether this critical piece of evidence was really critical or not. So I don't exactly know the best way to do it, but an allegation of IAC, that is something that we know. Whether they can actually prove it is what the trial court is for. Because, strategy of the defendant, like failed to call a witness. They never told me about the witnesses. I talked to the witnesses. They were terrible. All right. The second lawyer is not going to know that for the most part, right? They're not going to know the strategy. So allegation, maybe I don't know exactly how to say it, but I wouldn't say good cause and link it to an allegation.
Okay. Thanks, Judge. Lisa.
Okay, so I'm sensing some tension between Pam and Judge Christopher of why this is so difficult, right? Because, Pam obviously wants some substance, like Strickland's the standard, show the Court of Appeals that this is meaningful and a real problem before we disrupt this whole process and abate it. And Judge Christopher's like, I can't do that in 3 days. Like even a well-briefed motion, it's probably not going to be me. I sympathize with that completely. I don't know where I fall on it because, if it's really just based on an allegation, the problem is, well, everybody, I don't mean that. I mean, hopefully you have good appellate lawyers who are not going to make an allegation like this just to delay the process or, but there's a risk of that at least. So I was thinking more on Pam's side of that this motion would be a substantive motion that lays out probably not good faith. I probably wouldn't use good cause. I probably would do prima facie or something where they recognize the standard is high. They tell you why they think it's a problem here. And then the Court of Appeals, needs to say yay or nay, at least. Well, we can't review the entire record, but you showed us enough, so we're going to send it back. But Judge Christopher, I hear you, that's really hard for the appellate courts. I probably still lean Pam and hope you don't get a lot of these, but I probably shouldn't say that to you. You probably are like, no, vote with the judge.
I mean, I just think that there are a lot of claims of ineffective assistance of counsel, right? I mean, lawyers forget to object to things. Lawyers have reasons they didn't call witnesses. Lawyers might not know about the correct way to submit a case to the jury. But, you got to figure out ultimately whether A, there was an excuse for not objecting or not calling a witness, and then B, whether it would have made a difference at the end of the day.
So do you think
making a difference at the end of the day, on 3 days is just not doable.
Yeah. And then I guess the third category would be jury charge issues.
And even then, even if there is a jury charge issue, sometimes, well, it's very interesting. So on the criminal side, jury charge error is almost never error. The civil charge, jury charge error is always error. So, I mean, reversible error. It's kind of an interesting, if we're using Strickland IAC standards, and then we are imposing a civil jury charge standard, it's just going to be different.
Okay, so I'm just sympathizing. I'm open-minded to what other people have to say on that. I have a few other comments. I don't like that if the Court of Appeals doesn't rule on the motion for remand, it's denied by operation of law. But again, this is one of those things like, well, it can't really be granted. Like, we need something if they don't rule, and of the two, denied is, but it just seems to me if this is the one time that the terminated parent has an opportunity to raise that they had ineffective assistance of counsel at trial, it's hard that it could just like fall off some conveyor belts without them ever knowing whether the Court of Appeals actually took their comments serious. Like, that just kind of bothers me from a policy level. It might bother me even from a due process level. So I'm just pointing out things that bother me without telling you the solution or even how I would vote. And then I noticed in the rule that, first of all, I'm not sure we need to be told that the hearing needs to be recorded, but maybe. But then the trial court shall make findings of fact as to whether appellant was prejudiced. So why just the one prong? Like, why don't they need to show that it was significant error or whatever the first prong is? Like, why are we, like, what if there's a dispute? I don't know. I can just see it's a two-prong test and we're just telling him to make findings on one prong. And it seems like I can imagine a situation, though, when I put it on the spot, like right now, I'm not imagining it, where there could be also a factual dispute about both. So that just, I highlighted that as I was reading through it. And I think that's currently my comments, although I will not promise that those will be my only comments for the rest of this discussion.
Thanks, Lisa. Bill.
So to follow up on Lisa's last point, I need to confess to my inaccuracy of typing. that the proposed rule refers to findings of fact as to whether any counsel rendered deficient performance on behalf of appellant and whether appellant was prejudiced. So that mea culpa, that's my typing. I wanted to follow up on Chief Justice Christopher's question, because sort of the fork in the road that I think the subcommittee identified, and that now we're starting to explore, is the short timeframes are challenging. Okay, they're going to be challenging for a court of appeals if you went with this form of rule as is. And so really the balancing question is, are those concerns better addressed by elongating the timeframes that are contained in this rule and keeping a mechanism for doing this in the context of a direct appeal? So it's not 3 days, it's X number of days, and the abatement is Y number of days, and so on and so forth. Or is it better to channel this discussion towards an equitable or other collateral attack after the direct appeal is over? And that takes us back to the balancing of interests about whether the rules should be set up to emphasize additional time to review these claims, recognizing it's a difficult standard, while keeping the ultimate determination about the parents' rights and the children's relationship in limbo for a longer period of time, or potentially in limbo for a longer period of time. And so that's a long-winded way of asking this question, which is, if the timeframes can be adjusted to some doable, reasonable amount of time, is that preferable, or is the sense of the committee that we really need to avoid trying to shoehorn this into the direct appeal and deal with it some other way? That's kind of a threshold question.
Pam.
Yeah, I wanted to make the correction that Bill made, because that did get left out. And my other question is, this isn't an area where any of our subcommittee practices, so we're doing our best. We have been consulting with some people who do more of this than we do. But in terms of ineffective assistance of counsel, this is only cases that are brought by the state to terminate the parent-child relationship or to impose some type of conservatorship. So it's a very limited class of cases. I would assume that the jury charges are pretty standard in these cases. Lisa's shaking her head. No, they're not. Okay. So I was wondering if there really would be.
And I know I'm out of turn here, but just to answer that, the problem is this law is developing so quickly. There's been more emphasis on this area of law, and the statutes are changing. Like, I think they just changed last session even. So it's just sort of what I would call like radical movements of just judicial awareness of issues, and also legislative awareness of issues, and rights that weren't even recognized, 10 years ago. So I just think that we have Carlene polled as a big part of our docket are these termination appeals. And I mean, it's easy to see jury charge error and all kinds of problems, but it's just because it's just moving really quickly right now. That'll pause at some point, but right now it's moving quickly, in my opinion.
Okay, that's very helpful. Thank you.
Justice Gray.
This is going to be sort of scatological to try to respond to some of the different comments by the different speakers. And I was going to try to not say anything at all, but today on this, but here I am. One of the first questions that will need to be decided or addressed is who can file this motion, because hybrid representation is a problem that refers to a litigant that is represented by appointed counsel cannot appear and represent themselves. The situation I expect to see most often is an Anders brief filed in a termination counsel in a case by counsel, and then at that point the litigant wants to complain about counsel, either trial or appellate or both. And so that's going to be a problem. As far as the Strickland standard, it definitely cannot, should not, no way, no how apply to the motion. The motion needs to be more in the nature of a probable right of recovery, or probably in this context, a plausible ineffective assistance of counsel gets you the remand if that's what you choose to do, and the way you decide to approach this problem. The Strickland standard is to give the relief, not to get to the hearing. I guess one of my observations is that the most common to ineffective assistance of counsel, one that we see argued, two that we have actually seen in practice, is the failure to timely file the notice of appeal because they relied either on the 30-day rule and that it was a 30 days, so they missed the 20-day for accelerated appeals, or they miss it because they think one of the motion for rehearing or motion for new trial or to modify the judgment extended the time frame when in fact it doesn't, because it is an accelerated appeal. And this won't help us there because this is on, because this is all on direct appeal. If I was going to approach this problem, I would focus where Bill ended his last remark. Is this the place to do it in the direct appeal? And I would contend that it is not. If you allowed the appeal to proceed, let me make one other observation first. In the criminal arena, as Bill started off, we don't even get these substantive ineffective assistance of counsel claims effectively prosecuted through a motion for new trial when they have 90 days to present their arguments in a motion for new trial hearing. So the suggestion that you're going to be able to get this within 20 days after the record is filed, I just think is not going to happen. But I will say that if you want at least to have a procedure there that will catch the most egregious of these, I would argue that you should allow a motion for new trial to be filed in the trial court proceeding and let it continue to develop on an ineffective assistance of counsel claim while the direct appeal is pending. It would almost be like an original proceeding and a habeas type proceeding filed in the trial court that doesn't extend the time to file the notice of appeal, but you pursue that entirely separated from the direct appeal of the merits of the case. Once you get and it ought to be long enough that you can actually get the record in the appeal and allow this ineffective assistance of counsel or proceeding to be pursued simultaneously with the direct appeal. Whatever you do with regard to the timing and the methodology, you've got to remember that there's a statute out there. It's Family Code 161.211 that affects the time within which a direct or collateral attack on a termination order can be effected. And I don't know if this will cause us to bump into that or not, but it is a it sort of always has suggested to me that there is an opportunity for a collateral attack that could be pursued simultaneously with the direct appeal. And I'm going to scan my notes real quick. And of course, I agree wholeheartedly with Judge Christopher that the 3 and 7 day, and then with what Lisa said, the 7-day default to a denial is just, I can't gather together 3 judges in 3 days. I mean, much less try to get a ruling. So, I mean, that just is a really unworkable time frame. Scanning my notes quickly, I think that covers most of the points I was going to try to make. And I apologize for even re-engaging, but this is just not an area that, I mean, because you're going to get into Anders cases, and that is going to be what triggers the terminated parent to say, wait a minute, we need to talk to these witnesses that you didn't prepare the case at all. And then you go back into that whole investigation process, which is one of the big issues that is being kind of brought to the forefront in Anders cases, or in criminal cases, ineffective assistance of counsel now. Did you talk to this witness? Did you pursue this line of defense on punishment? And so trying to even get this done on a dual track system in 180 days after the trial judge renders the order is, I will say, an impossible task, but it, you know, we've been asked to do that before and accomplished it. So
Sure. Thank you, Judge. Richard Orsinger.
Thank you, Chip. I wanted to say that, first of all, to address Pam's inquiry, there's been a lot of foment in this area recently because some courts of appeals in Texas ruled that it was unconstitutional to submit termination cases on broad form, and they would require that you have individual questions for each parent and each child. And that was one of the things that the task force, House Bill 7 task force, addressed, and I think has been implemented. Maybe things will settle down, but there's been some turmoil in the area. There was a lot of charge error waiver for a period of time. I'm not sure that isn't going to go on, depending on how quickly the courts adopt it. But at any rate, for the time being, it's just been kind of an area of ferment. I've felt that we needed to have this addressed on direct appeal because we just can't effectively address it collaterally like a habeas corpus in a criminal proceeding. First of all, we don't want people bringing out of time collateral attacks to undo a placement or a termination in placement that has been affirmed by the Court of Appeals and reviewed, denied by the Supreme Court. And then now all of a sudden, how many months later, somebody's raising ineffective assistance of counsel and undoing all of that. I think we need to resolve the case permanently with the direct appeal. Either this removal is solid and you can place the child for adoption, or it's not, but we need to know that, in my opinion, at the end of the appeal. Secondly, what would be the mechanism for the appointment of a lawyer in a collateral proceeding if someone wakes up and says, I think I was ineffectively represented? This Court of Appeals says all my error was waived. So what do they file a motion with the trial court that doesn't have jurisdiction, asking for the appointment of an attorney? Where's the money going to come from? I just don't see how there's any mechanism for a lawyer to bring for an indigent parent an out-of-time collateral attack. On the criminal side, at least there are some private institutions and law schools that will do that pro bono, but I don't think so, not here in this era. However, the dual tracking that Chief Justice Gray suggested is very intriguing to me. I had never even thought of that before. We discussed on the House Bill Task Force about lengthening the motion for new trial period so that a newly appointed lawyer could investigate the claim of ineffective assistance, both from the standpoint of failing to develop the case properly, which would be calling the witnesses like Justice Christopher said, or just failure to object, which if you're newly appointed, you won't know that there was a failure to object until you have a transcript of the trial. The courts clerk's record. So the idea of dual tracking with a lengthened period to file a motion for new trial and a lengthened period to develop the evidence with the powers like deposition authority. For example, to take the deposition of these supposedly key witnesses that could have been called but weren't, to allow you to make your motion for new trial record and send that up while the case is already being evaluated on the normal. Maybe that's the best way to combine the two, rather than slow the direct appeal down to allow this evidentiary second look, run it in parallel, and then have the court at the end of the day, the Court of Appeals will issue one judgment on both claims. And there may be some scheduling problems. I know that the Court of Appeals justices, in particular, one in particular was, we need to, any time we add to the delay of the appeal, we need to add to their disposition period of the case, because they're going to get crowded at the end. If we give them time on the front end to develop all this, they're running out of time to hand down their opinion. And so that was why the task force recommended that we add on to their 6-month deadline whatever additional time we give. So having said all that, I feel strongly against a writ of habeas corpus out of time collateral review, but I'm intrigued by the idea of a dual track. Only the ordinary appeal is on one track and the motion for new trial is on the other track. Now, what the criteria are to qualify for the motion for new trial, I'm inclined to say it's either ought to be prima facie, showing that if believed, it would be warranted, or maybe something slightly stronger, but certainly not the standard by which you would ultimately rule on the complaint when you're on the panel on the Court of Appeals. That's too much to require in a showing that's that preliminary. Thank you, Chip.
You bet, Richard. Thank you. And there's been a chat exchange between Lisa Hobbs and Justice Gray. Lisa asking what the family code provision was regarding collateral attacks, and Justice Gray indicating it's family code section 161.211. So with that, we'll go to Justice Christopher.
So I like Justice Gray's 2-track system because I think the 3 days and 7 days, it's impossible to prove ineffective assistance in that period of time. So if the, second stage, the motion for new trial would have to be filed based on IAC would have to be filed, 20 days after the record is filed. And then, deadlines after that. I'm not certain I would do one, final appeal, but I might track it as 2 different cases, just because kind of treat it like a habeas, just from a, I don't know what I can say, just for an internal record keeping, I think it would be better. And plus, if the, for example, if the Court of Appeals for some reason was going to reverse the regular case, we don't even have to get to the IAC, right? So, we shouldn't be holding up the whole case on the IAC allegation that's going down a little separate track from ours. So I think it's an intriguing idea. It would take a little bit of work. It's basically a habeas proceeding within a really short period of time.
Great. Bill.
I wanted to come back to Chief Justice Gray's observation about how a lot, perhaps most of these IAC claims are going to get triggered by the Anders brief. And Anders brief is the last stage of this discussion, or the second to last stage. But I guess what I'm trying to figure out is how a dual track system would work if you've got track 1, which is the direct appeal, the main appeal. Anders brief is filed. There's no non-frivolous basis to go forward here. And the basis for that is, all the purported error was waived or whatever. And then you've got a simultaneous track addressing ineffective assistance before the Court of Appeals decides whether or not the case is going to get ended on Anders grounds. I'm getting confused about how that might work.
Justice Christopher?
Well, I mean, to me, an Anders brief will say, they didn't object, but they should also be, thinking, is that ineffective assistance of counsel when, they're going through the Anders brief? So, I mean, we could certainly include as a requirement of an Anders brief in these cases that I found no evidence of ineffective assistance of counsel. I mean, that's supposed to be kind of in there anyway. That would warrant this, habeas procedure. I just think that would have to be a potential requirement of any Anders brief. I do think that, and this is what we've done occasionally at the 14th Court, if we get an Anders brief by the same lawyer who tried the case, okay, we do not accept that. We send it back and tell the judge to appoint another lawyer to look at it, right? Because one of the jobs that the lawyer is supposed to do is to look for IAC. So, if he's the lawyer who tried it and then the lawyer on appeal saying nothing to see here, we've sent it back for a new lawyer.
What if you get a brief, an Anders brief, by a different lawyer, so you don't have the, somebody grading their own paper, and the Anders brief miscites the record on a critical point? For example, it says there's no basis to reverse because the father admitted that he beat the kid every day and really didn't care much about him anyway. Where the record shows that that's exactly wrong. He said, I never beat him and I love him to death. Is that ineffective assistance, and how do you handle that?
When we review an Anders brief, we review the record. And if we see that they have missed an issue or incorrectly cited what the case is about, we again send it back for a new attorney to write a new brief. So, okay. And we a couple of times we've done it several times. But, I mean, that's just what has to be done. Because you can't tell a lawyer, well, you screwed up, now write me a good brief. It's just better to get another lawyer to write it.
Is that practice consistent in the courts of appeals across Texas?
I think so. I'm not sure about the, if you were the lawyer who tried the case, you can't file an Anders brief. I'm not sure if that practice is consistent across the other courts of appeals.
But the situation I described, where a separate new lawyer just absolutely, I mean, he's ineffective. I mean, he messes up the appeal.
Yeah.
Okay.
We send it back.
Justice Gray.
Well, to directly answer Bill's question about the Anders brief triggering it, I'm talking about, and this overlaps with one of my other comments about hybrid representation. The only time that the litigant gets to, in effect, directly address the court is when they get a chance to respond to, well, I started to say motion to withdraw, but the Supreme Court nixed that part of the Anders process in termination cases. But when the appointed attorney files the brief that says there's nothing here to see, the parent gets to file a response. The parent, that is the first time that they can officially address the court and raise these issues that they may want to say either my trial lawyer or my appellate lawyer were ineffective for these reasons. Yes, in the Anders process, that gets trapped in what Tracy's talking about, where we as a court review what the counsel did and what happens at trial and make our independent evaluation of whether or not there was a meritorious issue to raise on appeal. But if we're going to allow at this point a ineffective assistance of claim double track, where can you move that off? And I'm not saying that it's going to necessarily arise in the Anders context only. I'm just saying that the person or lawyer raising the ineffective assistance of counsel does not need to be the trial counsel, does not need to be the existing appointed trial counsel, appellate counsel. I hadn't thought that deeply into it, but I can see the complaint about the lawyer first coming to the appellate court's attention as part of the response by the litigant, by the parent, in that response to the Anders briefing.
Okay. Thanks, Judge. Richard Orsinger.
Chip, I just wanted to ask the justices on the Zoom conference, does the Court of Appeals have the power, if they spot what they believe is ineffective assistance of counsel, to remand and ask for the trial court to appoint someone to brief that? And secondly, does that ever happen? Has that ever happened? Do they have the power, and do they ever do it?
At what level? The appellate attorney or the trial counsel?
No, it would be the Court of Appeals is reading the brief and they can see the waiver or error, or they can see the strategic or tactical mistakes and decide that this wasn't a fair trial or that wasn't due process. Does the Court of Appeals have the ability to say on their own, we would like to remand this to the trial court to appoint a new appellate lawyer?
Sua sponte.
Is the appeal an Anders appeal or a merits-based appeal?
I guess I don't know. Do you think the court has the power to just sua sponte to remand for an investigation of ineffective assistance?
No, but if it's an Anders case, we would.
Okay. But if it's a court-appointed brief, you don't have that power, you think, huh?
I don't think so.
Okay.
It's not an issue that's been presented to us, and we'd have to get there some other way.
Just to follow up Richard's hypothetical, if you're reviewing the record and on the face of the record, the trial counsel has been beyond all shadow of a doubt ineffective. I mean, he's asleep, he's swearing in court, he's he's being mean to his client on the witness stand. You don't have the power to remand it for an ineffective assistance inquiry.
No, I mean, if the lawyer doesn't bring it up as a point on appeal, we cannot, right? If the lawyer brings it up as a point on appeal that there was ineffective assistance of counsel,
of course,
on occasion, we grant those. The vast majority of the time, we say, in our opinion, the evidence is not developed on this point, and see you later. But because in the criminal context, they have the habeas,
yeah,
right, where they could develop the evidence later. Here, we don't have that, so that is something that we need to think about, right?
Right.
And Justice Christopher, I'm not suggesting that you would reverse on unassigned error. I'm suggesting that you might remand to the trial court with instructions to get a new appellate lawyer to raise that point of error so you can rule on it. I know that sounds convoluted, but that would comply with the rules of appellate procedure, it seems to me.
If a rule is written that says we can, I guess we can. I mean, I don't think we can at this point.
Could we get another 80 or so appellate lawyers if we're going, appellate judges, if we're going to start being the lawyers for the parties?
I mean, we don't want to accidentally miss something, right?
We'll bring it up with the legislature.
I mean, because you can look at a record and see they called no witnesses. And you might think to yourself, oh, come on, surely there was someone they could have called to say that this was a great mom or a dad, something that they could have done, but we don't know that.
But bear in mind, and for the rest of the people that not like Jane and Tracy and myself and Justice Heck that have seen a lot of these by now, understand that in many, many of these cases, even Rusty Harden could not have kept the termination from happening. I mean, it's gonna happen, folks. I mean, it is just there. Now, I have seen one in particular that it should not have happened like it did, because there was literally no evidence introduced into the record upon which to base a termination, period. But that was not presented as an issue on appeal that I could deal with. Now, I was still in the dissent in that case, but there were other issues but I'm just telling you, that, like Tracy said, there are times when we can see a problem, but there is not a way for us to get to it. And usually, and I will say 999 out of 1,000 times, it would not affect the result in the case. But there may have been malpractice, there may have been ineffective assistance, but it is not to the point that it would have affected the result in the case, even if they had done what they should have done.
Yeah. And, sometimes on the criminal side, when we have the, failure to present witnesses, failure to investigate, it's almost always in the sentencing aspect that there's any sort of reversal for a new, sentencing hearing. Usually, like I was talking about, oh, isn't there some witness you could have called to say you were a good parent? The vast majority of the other evidence, even if you called that one witness to say, oh, she was really a good parent, it would not meet the Strickland standard, right? It just would not be. So lately, we've been having trouble with clients not showing up and how lawyers are handling that in the situation. So that's an interesting question in these cases.
Yep. Lisa?
Chief Justice Gray, I really like your idea of this sort of dual track that I don't think is anything really the House Bill 7 group looked at. I'm Judge Boyce, I do think about your question too with how this works. And I think that's part of the problem, right? It's like we're asking a trial judge to say, yeah, it was a big deal. They really, really, really messed up and it's prejudicial. And sometimes we won't know if it's prejudicial because we don't know how the direct appeal is going to end up, right? So in your mind, Judge Gray, would the trial judge just like take a gander about like how this is going to come out and that it's probably going to get affirmed and not reversed and ship it on up so that they can be on parallel tracks? Or would the trial court maybe have like some ability to abate the ineffective assistance of counsel habeas or whatever we're going to call it, so that we can wait and see what the appellate courts do on the direct appeal?
I personally would try to get the ineffective assistance of counsel case out in front of the direct appeal myself, but you know, I would just pursue them completely. You can't do them completely independent, but one of them is going to get to the finish line first. And I don't really think that it would matter. I mean, it's because if you get to the finish line on the direct appeal and it's an affirmance, that doesn't necessarily, it may even help the habeas case on ineffective assistance of counsel.
No, affirmance would, but reversal would not.
Well, that would just potentially moot it, and hopefully the trial court wouldn't appoint the same counsel again. But at the same time, maybe the trial counsel that was ineffective the first time may know where the landmines are buried the second time. I mean, it's
maybe
Well, and
motivated.
on the other side, in the habeas, the trial judge might say, okay, I'll give you a new trial.
exactly, and moot the direct appeal entirely.
Right.
So I would not say that one has to be pushed before the other as a matter of the rule. They're just set them up as separate tracks. I mean, the one thing you're going to need that's different than a traditional motion for new trial. And remember that in a criminal case, that to get an evidentiary hearing on a motion for new trial, you have to present in the motion that you need an evidentiary hearing. It has to be something upon which you need to develop evidence to be able to get that, to be entitled to the hearing. But in this arena, you're going to need more time between the time that the motion for new trial is filed and the time it is overruled by operation of law, because to really make that a meaningful track, you have to have the trial court record. That's the only way that makes sense. Just like normally in the criminal arena, after the direct appeal is over, then you go back and you wade through the record. And that's why these writs for, capital punishment go on for decades after the fact, because they go back through in detail everything, re-talk to the witnesses, re-interview them. You do all that 2 or 3 times, and it takes time to do that. I'm not talking about taking that long, even though terminations have been called the death penalty.
No, but you've actually raised a good issue with and again, I like your idea. I'm just trying to I'm not trying to pin you down. I'm just trying to decide if it's worth Judge Boyce's time to explore it. But okay, so we need the record. We can, so I don't know if by rule we can extend the trial court's jurisdiction. So I guess some motion would be preemptively filed to, maybe we can, maybe I'm wrong on that. Maybe I'm just trying to think about what is the basis of plenary power.
I think it's Rule 329B, Lisa.
It's just rule based?
I thought it was. Now,
That's probably right.
The terms of court are statutory, but I don't have my rule book right here, but I've always looked at 329B as.
Oh, no, we all look at 329B for sure. But I'm just wondering if 329, if there's a statute that supports, can we jack with that by rule, or was that set up by a statute or something? But if plenary power is a judicially created doctrine, then I don't see a problem. I'm sorry, I'm thinking out loud, and I probably shouldn't be doing this on advisory committee, but this is probably a subcommittee conversation, so I'll stop.
Well, as long as you're, kicking the jurisdictional idea around, just remember that NG compels the courts of appeals to decide at best advisory decisions, or to make it at best an advisory decision of something that might happen in the future. And that's the case that requires us to write on D or E if it is challenged as a ground for termination, because it might be used at some other point with some other child in the future to terminate on another statutory ground.
I'm
And,
still bitter about that one.
and it's purely an advisory opinion. Thank you, Tracy. At least Tracy knows what I'm talking about. The rest of y'all may have no clue, but
No, I do. I just disagree with you. So I'm just keeping my mouth shut.
At the risk of jumping into this three-way inside baseball conversation, Bill, once we are done with this, have we reached the end of the road of your work on appeals in parental termination cases, or do we have something else that we need to discuss?
Oh, there's more.
Okay.
So
And-
specifically Anders procedures and so forth. And
yeah.
Also templates for briefs and opinions.
Okay. We're not going to resolve that in the next 10 minutes, I assume.
Doubtful.
Excuse me?
Doubtful.
Certain.
Should we put this over to our October meeting?
Pam is urgently waiting, so I think maybe she should weigh in, and then I'll make an observation.
Yeah. Okay.
I just want to say this has been very educational for our subcommittee. I really want to thank Justice Gray and Justice Christopher for their insights on how it works on a daily basis. I do think, it's intriguing to think about having this sort of parallel proceedings. The problem is it doesn't necessarily avoid an ineffective assistance of counsel claim later after the appeal is concluded, either complaining about the appellate lawyer's activities or whatever. So we'll still be getting into this. And then the question is, does it make sense to have two different, basically sort of parallel habeas proceedings, one that is ongoing at the same time as the direct appeal, and then one that's at the very end after everything is over. So I guess if everybody would give that some thought, we are running out of time, so we probably can't discuss that today. But these are very complicated issues, and you have given us new insight. I'm not sure that we have a perfect solution. Bill.
I guess what would, I think, help guide the subcommittee's further deliberations is whether it is the sense of the committee that it would like the subcommittee to try to see whether this dual tracking is really feasible or not. I'm mechanically, I'm still tripping over some stuff, but that doesn't mean, the issue should be dropped. So I don't know if I'm calling for a vote, but I've heard some expressions of enthusiasm for looking at this. We're happy to look at this being a dual track proposal, but Pam's point remains salient, which is even if we were to come up with the exquisitely perfect dual track deal to go alongside the direct appeal, that's probably not going to cover every conceivable type of IAC circumstance that could arise. And so we're still looking at some kind of post-appeal collateral attack for some circumstance. And maybe it's a narrow circumstance, but I'm not, unless I'm missing something, I'm not sure how we avoid having to do that.
Yeah. Well, my own feeling, Bill, is that subject to being overruled by either Chief Justice Hecht or Justice Bland, I've heard enough that it sounds like this could benefit from further study and discussion in our October meeting. But as I say, I'm more than willing to be overruled by the members of the court if they've heard enough and don't want the subcommittee to expend the extra effort. So that's where I come out on it.
And Chip, if I could just, not to interrupt before the judges say anything, but I think, Bill, you're going to have to do a post-appeal process anyway, because we're all working under the assumption, well, mostly, not every conversation, but most of the conversation here has been a separately appointed appellate counsel. And it has not been the case of the trial counsel, like handling the appeal him or herself. So I don't know how you get around not having, some kind of true up of where you effectively represented through the whole process under any circumstances, honestly. So I interrupted you, Chip, only because you were asking the judges whether it's worth the time. And I just wanted to add my thought that I think that time is going to be spent. And the question is, who falls into that procedure versus, yeah.
Yeah, and maybe I was inartful in the way I was posing the question. It did not seem to me that we could have a vote of the full committee, because I don't know what we could possibly vote on that would be meaningful. So that's really what I was where I was trying to be helpful. So that's where I come out.
Well, for my part, I don't think we've got a solution. So I think we have to keep working on
it. Yeah. Said in about 5 words what I was trying to get out. Justice Bland, would you like to dissent from the chief there?
No, and I would say that what we're really talking about, whether we do it via an abatement or some other proceeding in the trial court, is some sort of out of time evidentiary motion for new trial hearing. And the criminal side, they allow those in cases very rarely, but they allow them for notices, out of time notices of appeal and things like that. And there was a whole series of cases called Jack, where people said, let's have this new trial hearing as part of the appeal. And the Court of Criminal Appeals said, no, we're going to all do it by habeas. But because habeas is just so problematic in these cases, because it's not just the criminal defendant's rights that are at play, query whether it's better to do what we're doing, but do it in the context of the direct appeal, albeit with more time allotted to the trial court and the Court of Appeals to make a reasoned determination about whether there's merit, and whether there ought to be some sort of prima facie showing before you've got that sort of extraordinary relief. So I think we're all headed towards some process in the trial court. It's just a question of what triggers it, when, and how long does everybody have to complete that process. I continue to think that collateral attacks in these kinds of cases just have a whole host of problems that, if we could find a solution where we could do it inside of the appeal, it would probably be good.
Thank you, Justice Bland. So on October 8th, which is still hopefully going to be in person, we'll have seizure exemption rules and form as the number 1 item, since we have a time deadline on that. And this matter will be our number 2 item on the agenda. I'm saying that for Shiva so that she and I can keep track of these things. And I think it's been, as usual, a terrific discussion today. And the amount of work is just, that you all put into this is mind-boggling, and it's just fabulous. And in the 1 minute left before we recess, Pam Barron and Robert Levy can second my gratitude to the full committee. Go ahead, Pam.
Well, certainly that. But I did have a question on the October meeting. Assuming it's in person, will there be any virtual options for old people who maybe shouldn't be traveling like me?
Yeah. We were exploring and with, I think, some optimism and success, a virtual option for this meeting when we decided to hold it virtually. And I was struck by the fact that if we can't do the technology for a hybrid, in-person and Zoom meeting at the Texas Association of Broadcasters, then where could we come up with the technology to do it? So no definitive answer, but optimistic that we can, and we're going to try. So that answers that question. Now, Robert, and then Professor Carlson, in the 30 seconds you have left.
I just wanted to thank you for a great session, but I have to know, where is Levi Benton? Wakanda's not going to cut it.
Yeah, no, it's not, and it's just so wrong. Him being wherever he was.
I'm sorry, I'm in Wakanda, but since I was called on, I have a comment or a question also on another topic. I wonder if the chief and/or Justice Bland were sufficiently informed and at liberty to address what Chief Justice Christopher raised earlier. What in the world is going on in Brazoria County?
They're certainly welcome to comment if they're able, or if they know.
Comment.
So that will be a no comment, Levi. Sorry, Elaine, Professor Carlson.
Hey, Chip, I just want to mention, we do hybrid at the law school. I don't know the technology, but I'm happy to ask our IT people to speak to whoever you need to coordinate with on that.
That'd be great. Shiva,
Chip, I
yeah.
had a hearing 2 weeks ago in Comal County that was hybrid. If Comal County can do it, I'm sure that the Association of Broadcasters can do it.
You would think they could, but Shiva, in lieu of going to Comal County, which is a delightful place, if we run into trouble in Austin, let's note that Elaine might have some resources for us. All right. Well, this once again has been great. We've gone 2 minutes over. Sorry about that. But it's great to see you all, even if it's virtual. And I really hope that next time we can be in person. And that night we're going to have a reception and a picture. So to the extent that people can get there, that